presentation will be about the 2015 Supreme Court case Lanell Williams Yulee versus the Florida Bar.
My name is Kate Wall and my partner is
Malgilizu.
The order we will be discussing this case. First as follows. Background information, facts, legal issue, the law, opinions of the court.
Then the holding analysis, and then the conclusion that will conclude our presentation.
The icons are there to help the viewer know who is speaking if they are unsure. So the gray fox is me, Kate.
And the tanuki is me, Mel.
Background information. Background information about Florida Judicial Court. Florida is one of the 39 states where voters can elect judges at polls for the circuit court and for the county court. Selection of judges through polls is a 6-year term. Judicial candidates have campaign committees to ask people for donation to their campaign. Florida and 29 other states ban personal solicitations to protect public trust and confidence in the justice system. Judges and judicial candidates have to follow the Florida Bar Code of Judicial Conduct. Background information about the case. Lanell Williams Yulee. We will be referring her to Yulee throughout the case and presentation. She ran for county court judge in Hillsborough County, Florida. She personally asked people to donate money to her campaign. However, Yulee lost the judicial election. More background information. The Florida Bar disciplined Yulee. Yulee was fined for $1,860 for violation of Canon 7C of the Florida Code of Judicial Conduct, personally soliciting financial contribution for her campaign. She then sues the Florida Bar. The facts about the case. The plaintiff is Lanell Williams Yulee. The defendant is the Florida Bar. The conflict. Yulee declares that Canon 7C of Florida Code restricts her First Amendment freedom of speech. Yulee states that she has the right to ask people to donate for her campaign.
The legal issue of the case. The question the court must answer, does a rule of judicial conduct that prohibits candidates for judicial office from personally soliciting campaign funds violate the First Amendment? The laws involved in this case as follows. The statute or state law that will be focused in this case is the Florida Code of Judicial Conduct, which is the standard of ethical conduct of candidates in judicial elections. Canon 7C1 is part of the law the case will mostly focus on. Canon 7C1, Rule of Law as stated, competing candidates shall not personally solicit campaign funds or solicit attorneys for publicly stated support, but may establish committees of responsible persons to secure and manage the expenditure of funds for the candidate's campaign and to obtain public statements of support for his or her candidacy. The constitutional law being challenged is the First Amendment involving the freedom of speech. The Supreme Court will review this case under strict scrutiny given speech is challenged by a certain law, Canon 7C1. The court will determine whether the law served a compelling interest and narrowly tailored.
Opinions of the court. It was a 5-4 majority. The visible ones are the majority, the fatal ones are the minority.
Chief Justice Roberts wrote the majority opinion. Justice Sotomayor, Kagan, Breyer joined in full of the majority opinion. Ginsburg joined except for Part 2, which concerns scrutiny. In Roberts' opinion, he affirmed his judgment for Florida Bar. The court held that the limitation of speech in context subject to application of scrutiny in this case was strict scrutiny. A state may restrict speech of a judicial candidate only if restriction is narrowly tailored and served a compelling interest that the law is constitutional. Canon 7C1 did serve state interests of Florida of banning personal solicitations for the purpose of preserving and protecting integrity of judiciary and public confidence to prevent the appearance of corruption. States may regulate judicial elections. The law was not under-inclusive as Yulee claims and did not undermine states' interests. The court finds the law has no exceptions. There are alternative means for candidates to raise funds. The law was written to the intended goal. Here is an excerpt of Chief Justice Roberts' majority opinion. Judicial candidates have a First Amendment right to speak in support of their campaigns. States have a compelling interest in preserving public confidence in their judiciaries. When a state adopts a nearly tailored restriction like the one at issue here, those principles do not conflict. A state's decision to elect judges do not compel it to compromise public confidence in their integrity. The concurring opinion. Ginsburg wrote a concurring opinion in part and in judgment. Breyer joined in part 2. For Breyer's opinion, he wrote about the application of strict scrutiny. As stated in his opinion, tiers of scrutiny as guidelines to forming an approach to the case at hand, not tests to be mechanically applied. Ginsburg's opinion, she wrote that there was no need to exacting scrutiny to tell apart a judicial election from a political election. Instead, states should impose different campaign finance rules for judicial elections role of judges, because judges differ from politicians when it comes to their roles. States should have a broad latitude to regulate judicial elections.
The dissenting opinion. Justice Kennedy, Justice Scalia, and Justice Alito filed dissenting opinions. Justice Thomas joined Justice Scalia's opinion. Justice Scalia's dissenting opinion, joined by Justice Thomas. The First Amendment, freedom of speech. As a general rule, the state has no power to ban speech on the basis of content. Canon 7C prevents judicial candidates from personally asking people to donate for their campaign. There is a contradiction between the First Amendment and Canon 7C. Scalia said this should be a straightforward case. Canon 7C is unconstitutional. It goes against First Amendment. There is no straight scrutiny. Sleight of hand means deception. This case looks like straight scrutiny, but it is not. Justice Kennedy's dissenting opinion. The First Amendment, freedom of speech. Candidates are able to talk about themselves and the policy they represent. Restriction on asking for funds or cutting their speech. They should be able to ask for money. Straight scrutiny application is not narrowly tailored. Not wealthy candidates can't even ask relatives or friends to donate. This case will serve as a precedent that will allow courts to ban any speech they dislike from judicial candidates. Justice Alito's dissenting opinion. He agrees to the elements of Kennedy and Scalia's dissents. The test of scrutiny, straight scrutiny failed, not narrowly tailored. The court should reverse the judgment. Florida court violated the First Amendment.
The holding. The holding affirmed Florida's Supreme Court judgment. The Supreme Court of the United States held that the speech restriction served a compelling interest and was not under-inclusive and was narrowly tailored and served the goal of the state. Canon 7C was valid.
Analysis. Straight scrutiny is applied to this case. The case compares judicial election with political elections. Freedom of speech was not infringed. The conclusion. Recap. Yulee sues the Florida bar for violating freedom of speech for judicial elections. Supreme Court gives judgment to the Florida bar under strict scrutiny. The significance. With judicial integrity in relationship with judicial elections. Public trust in the system.
Here are some quotes to illustrate the significance of this case. The right to all manner of people without fear or favor, affection, or ill will. Oath of allegiance from the United Kingdom, but not these images though.
Administrative justice without respect to persons and do equal right to the poor and the rich. Oaths of justice and judges, but not like these images.
To no one will we sell to no one will we refuse or delay right or justice. Magna Carta, but not these images, of course not. For more information about this case, here are some links that might involve your interest.
The Supreme Court of the U.S. has no camera rule for its deliberators and arguments, but allow audio available for the public. The first link is the oral argument with animals reacting the court to make it interesting, since the court does not allow video.
The second link is of John Oliver from Last Week Tonight, his show discussing about elected judges and solicitations, which is entertaining and informative.
Last is a video for the process of judicial elections made by one of the county of Florida.
Question to the viewers, what do you think about this case, and do you think this was a good decision?
Any questions? Please leave a comment below. That is all.
Thanks for watching.